So the agenda for today is like we will spend some time understanding what's intellectual property rights, and we will see what are the different types of IPRs that are available. And patent, which is a type of IPR, is what we will spend some time today, delving deep into. And then we will also understand why one should care about patents and some examples that I have picked up from various different functions, right? And we will also spend some time understanding what is not patentable, because it's very important to understand what's not patentable, and the patent filing process, and the flow that is followed in India, and what is the process to follow an international patent filing. Right? And then we will conclude with some trivia and patent and some useful references. So let's get started, right? So first off, we have to define and understand what we mean by property before even we understand intellectual property, right? So property or asset is interchangeably used. So property or an asset is nothing but a physical or intangible entity, right? That has certain owners, and by law, certain rights are assigned to these owners. Owners could be group of people, or it can also be an individual that owns that property or an asset, and it could be a legal entity like an incorporated company and things like that. And certain rights to sell, rent, mortgage, and to transfer the asset or property and exchange it for something else in return, and you can even scrap or destroy this property. You can, of course, exclude others, right? Create a fence so that others, do not acquire your property, or try to copy or possess your property, right? Infringe upon your property. So this is typically applicable to a property, right? Moving on, let's understand what's an intellectual property, right? Intellectual property is nothing but is a creation of mind, right? Any innovative creation of the mind can be called as an intellectual property, where you apply your mind and or intellect, and come up with a certain idea, process, or a product. So intellectual property derives its power from idea, right? So idea itself can't be called as an intellectual property, because two people could have the same idea, right? But of course, the intellectual property derives its power from the idea, right? And we have to understand the difference, right? Many times people confuse idea with intellectual property. They are different. Of course, it's from the idea. The intellectual property is derived, right? Just I think people here, right? So, and you can assign owners to these intellectual properties, and it has a monetary value, and it is legally bound. Whoever is owning this intellectual property enjoys certain rights legally. So that's about the intellectual property. Okay. Move on. So intellectual property rights, right? So basically, why do we have to, let's say, protect the intellectual property? As I told you, the intellectual property rights are given to the owners of these intellectual properties by law, right? Why is it required? Why should we give certain rights to those people who own that intellectual property? So when I say own, it could be the original creators of these intellectual property, or those people who invested in enabling those creators, or somebody who buys these intellectual property. So owners could be any one of these three people. So basically, whoever is the owner, so he has to benefit from that, because it fosters innovation, right? If you don't protect the innovation, then it is liable to be copied and imitated. And so you have to protect that, and also the creators should be equally be rewarded, so that they keep creating more and more. So it is very important to protect or have a very good intellectual property rights regime. and it encourages fair trade and, of course, the diffusion of knowledge, right? Because let's say I invent something and keep it close to my heart, and if I don't divulge the information, then it's of no use to anybody, right? Such an innovation is of no use. So the knowledge has to be spread, and people should start using that knowledge to create improved processes and products. And of course, it promotes economic and social development. We just discussed, right? So protection from infringement, and it gives the sole right to use, make, and sell, right? And it kind of prevents others from doing it. So that's again another reason to have the intellectual property rights in place. And you can earn royalties from the intellectual property, and it of course gives you certain business advantages over others. And for implementing the IPRs, there are certain protocols and agreements between different countries. At an international level, there are certain protocols and treaties in place which will protect the intellectual property rights of the creators. So moving on, we have seen about the intellectual properties, but what are the different types of intellectual property rights, right? So there are at least 8 different classifications of intellectual property rights. So the first one is trademarks. I think it's an overused word, and many of you will definitely would have heard about this, right? Trademarks are a type of intellectual property rights which pertain to certain symbols and signs and expressions used in business, right? For example, the logos of different companies and certain signs used by companies or businesses are an example of a trademark, right? And in fact, these days you could even register a sound, for example, the typical Intel Inside sound, or things like that, or an Airtel tune and stuff like that could also be can also be considered as trademarks. And there are also smell marks that are coming up, right? Certain smell, let's say a perfume smell or whatever smells that you come up with, you could even go and register those things, right? So that's about trademark. And then copyrights, which is applicable to the literary work and artistic work, typically a DVD record, and let's say lyrics of a song and stuff like that. So which all come under the literary and artistic paradigm, could be covered under copyrights, which is a type of IPR. And then the third one is a patent. Right? A patent is a kind of an IPR which is applicable to processes and products which are non-obvious, novel, which is new, and it has to have an industrial use, right? So such things are covered under the patent IPR. And then the industrial designs, right? So it is applicable to the articles that embody protected design. Okay, so what we mean by that is, any product will have a look and feel as well as certain functionality, right? So the functional part is covered by the patent, right? So what that product is all about and how it is implemented, what does it do, how does it do, etc., is covered under patents typically. And the industrial designs IPR is all about the look and feel, right? So we call it as form and functionality. It's all about the form of the product, right? So let's say the design of a Vespa scooter would be, say, an industrial design which could be patented, for example, right? And then moving on, we have geographical indication. I think this is something that I'm sure somebody, you would have been exposed to, definitely, as a type of an IPR. So it pertains to those products originating in a territory, region, or a locality. For example, it could be a Darjeeling tea, or say a Kanchipuram silks and stuff like that. They say the Tirupati laddu and stuff like that. So they are all a good example of geographical indication. Then moving on, trade secrets. So trade secrets pertain to the certain formulas and the processes that are involved in, let's say, producing something, and a certain design or pattern, and some information, right? For example, the ingredients of Coca-Cola is a good example of a trade secret. So then we have plant varieties. So it applies to new plant varieties. And another important thing is the IC layout, right? Integrated circuit layout. That is again covered under IPR types. So important stuff is it's not covered under patent, but it is going to be covered under what is called as IC layout and designs, which is a separate law, right? So that's for semiconductor IC layout. So these are the 8 different types of IPR. And so we, as engineers, mostly deal with patents, right? So so let's focus mainly on the patent IPR for this talk. So patent, it's a type of an intellectual property, right? So what does it do? So it is applicable to a new product or a process that solves a technical problem in a novel fashion, right? And it has to have an application, industrial use, for something to be qualified as a patent as well. So patent is granted, and it is what to say, applicable for a specific period of 20 years is the validity period. And after that, you cannot renew a patent, and a patent will become null and void after 20 years. So that's the time period, right? And for you to get a patent awarded, you have to give the technical information about your invention, right? So completely, you have to disclose your invention, and in turn is what you get those intellectual property rights for you to sell, and whatever rights that are provided to you to protect your invention. So you have to completely give the technical information or the know-how about what you have invented. So that's the point. So, I mean, why should we even care about patent, right? So we've been talking about patent all the time. So first of all, it's an asset. And if you are a company, so it obviously protects your investments that you have made to create these intellectual properties, and provides legal rights, right? And so that you can sell, license, exchange the asset or the IP. And it increases the valuation of your company and gives you control over products and markets. What if you are an individual, right? So it helps you to differentiate yourself from others, and it of course helps you earn some money, right, as royalties and licensing fees. And so you get internal and external recognition. Many companies today have reward policy for filing patents, right? So you could utilize that, and of course it helps you move up the ladder because you stand out, right? And so thinking is a habit, right? So once you have one patent, it is very likely that you will file many more, and you just can't stop thinking, because thinking is a habit, and so you've got to get better ideas flowing, right? So of course, yes, you should definitely care about patent, whether you are a company or an individual in today's competitive world, to stand out or to differentiate yourself, or to increase the valuation of your company, and have control over the markets. So let's see some examples of patents, right? So I have tried to get a few examples from different fields or different functions, like let's say a product design, and say verification, and implementation, and something related to the DevOps, which is more of a software concept, right? So first one is a tilting camera, right, from Samsung. So if you see this picture, right, so it has all the details, right? It is just one picture that I have actually taken from the patent document. There'll be several such pictures, right? So you have to talk about how you are implementing your idea, right? The implementation information has to be given, and that's the key. As you can see here, they are talking about how the sensors are arranged, and what is the functionality of that sensor. So this patent, if you're interested, you could look out. And so it just talks about, instead of moving the whole camera to take a panoramic shot, actually the whole sensor here is going to move sideways as well as up and down, so that you can take a panoramic picture, for example. So that's one patent, right? And then the second one is related to the verification using generic protocol adapters. So here they are talking about a framework where there'll be a generic VIP transactor, which talks to an adapter. For example, if you want to support AHB and AXI, you could have a generic VIP, which will have APIs that support all these kind of transaction to be initiated from the application level. And you could have an adapter. For example, if the DUT is going to support AXI, then this adapter could be made in such a way that it actually converts these generic transactions to AXI. And if it is AHB, accordingly, it could do it. So this kind of a framework is being talked about in this patent, and it is filed by Qualcomm, and it is pretty much available in public. And there are many more. It's just not one, right? There are tons of it. You can just look up, right? Because I hear many times people say that, look, verification patenting is very difficult, and I don't know how to do and what to do, etc. So it is possible, and people are doing it, and it's from very popular companies that many of us have worked and stuff like that. Then the third one is from Intel, where they are talking about dynamic power reduction, which is a popular technique, right? Where you determine the idle functional blocks and then go and reduce the VR of the voltage regulator, right? So that is from Intel, and that's again available in public domain. And so there's another one from IBM, which talks about DevOps. So DevOps is a method to ensure good quality products, and it ensures that the design and testing happens together hand in hand. So there they talk about executing the test in a certain environment, collect the metrics, and then keep it as a golden reference, and then try to do the same set of things in the say in some other environment, then compare the results, and thereby help identify the issues upfront and understand what kind of issues could come if it is actually deployed in a say some other setup. So these are all examples from different drawn from different functional areas, namely validation, verification, design, and say implementation. So you could look up. There are tons of it. Just for your information, I myself have a patent, and which is again related to implementation. So I have not covered it here, but yeah, it is pretty much possible to do it if you are a hardware engineer or a verification engineer working on verification or validation, or say on the design side. So it's pretty much possible. And so let's spend some time understanding what is not patentable, right? So for something to be patented, I told you that it has to have an inventive step, which means something, it has to be new, which means it should not have been known to the say the public earlier, right? And it has to have an industrial use, and it has to be novel, right? So in terms of what is not patentable, so so these are the statements from the IPR website, right? Indian Patent Office. So you will see those statements. So I'll just read out and explain it, right? So any invention which is frivolous or which claims anything against well-established natural law is not patentable. So what it means is, like, you can't, let's say, just for fun sake or just for the heck of it, just come up with some idea or some implementation and then say, hey, I want to patent it. Because one of the criteria, as I told you, it has to have an industrial use and application, right? So, so obviously, under that law, under that law, it becomes null and void, and you can't actually patent it, right? And anything that is against the natural law, you cannot come up with a device that says, okay, and prove that, okay, there is no gravity in the whole world, right? So that is not acceptable. Likewise, anything that is going to harm the human or say the animal, plant, and the planet in general, and it's going to, if something is hazardous to the health, so such things are not going to be accepted as a patent, right? So it will be discouraged. Any scientific discovery, so discovery is nothing but finding something which is already existing, so they get classified as scientific discoveries, and obviously they are not patentable. And any principles, scientific principles, say for example law of gravitation, and so certain physical principles and stuff like that, you cannot just go and patent them. And a mere research, right, without any application, cannot be patented. And also, say, rearrangement of a machine part or a machine without any change in output can't be patented. For example, you can have a typical example is you have an umbrella, and inside an umbrella, let's say you fix a small fan, and have a switch to activate that fan. So fan is a different entity and umbrella is a different entity, which is very well known. And you are now taking these two parts and combining and then saying, hey, okay, I have this product. So here the output is not changed, right? So the fan behaves like a fan and the umbrella does the functionality like it's an umbrella. So you cannot claim a patent for such a thing, right? So, and then mathematical or business methods or an algorithm per se cannot be patented, which applies to computer programs as well. So this is very important. So computer programs are generally covered under say copyrights, right? So it's considered as an artistic work. But of course, if there is a computer program which is part of a product, and if that product does create some output, then obviously you can patent that. But a mere algorithm per se is not patentable. But in the wake of machine learning and stuff, there is a new paradigm that's coming up, and we might want to look into that totally differently. So that's about it. And any traditional knowledge can't be patented, right? So cannot be patented. So which means like say applying turmeric to the wound, we know that in India we have had that knowledge for centuries. You know that it heals the wound. So you cannot take it, or you cannot say, hey, here is a process by which I apply this turmeric and it heals the wound, and so I want to patent this method. No, that's not possible. And topography of integrated circuits, we just spoke about it. So the integrated circuits and its topography, which is pretty much nothing but the floor plan and the arrangement of the blocks. So that is covered under a different IPR. It's not covered under patents, right? And any presentation of information, let's say today now I'm presenting this information with certain, in a certain way. So you cannot go and patent that. And then admixtures without any therapeutic effect, right? You cannot take 2-3 chemicals or combine certain things and then say, hey, okay, it doesn't have any therapeutic effect, but this is something that I have come up with. It looks great or smells great, so I just want to go and patent it. Yeah, no, you can't do it. So these are some things which you cannot patent, and you can actually look up here. It's all available there in the IP India website. So now patent filing and grant. Right? So how do you go about filing a patent, and how do you get a grant? And first off, you have to very clearly define the invention, right? And resolve the ownership. So this is a very crucial step because most of us will be involved in this step. So it is possible that several people have, say, the same idea, and of course, people would have also, let's say, helped or come together to come up with a certain way of implementing it, say implementing a product or a process. So now we have to resolve who the owner is or who are the owners, right? And that has to be resolved upfront. And you have to, before that, you have to very clearly define what is the problem you are solving and how you are solving very clearly. And you also have to do what is called as a prior art search and a patent, and that's also called as a patentability search. So it allows you to know if there are any pre-existing patents that you might be infringing upon, and if so, you could actually go and work around your idea and implementation. So it is very important. And sometimes you also quote as references all these all these existing patents which look very similar to your idea. So This has to be done. Typically, step 1 and 2 is done. Is, let's say if you are part of an engineering team which files patents, then obviously 1 and 2 is something that you have to do. Sometimes 3 is also done by the engineering teams, but it could as well be done by the patent office, which is present within the company, right? And for step 4 is a major step where you actually do a complete documentation of your invention, where, as I told you, patents talk about the functionality, right? So we have to very clearly talk about the area of invention, the working principles and the diagrams, and of course the advantages of the invention. So don't spend time talking about the features and benefits of your product, because that is not what is important for a patent application. So you need to tell how you are doing and what you are doing, right? And of course you do talk about the advantages of the invention, but primarily the focus is on the functionality, and yeah, so that's about it. Then filing patent is a very costly affair, right? So if you are going to do it in multiple geographies, it could cost you a few $1,000s. And so you have to be judicious about it, and you need to decide really on which countries you want to file the patent and you want to cover, right, and protect it. So that's step 5. So typically, step 3 to 5, you employ. Obviously, step 4 to 5, you tend to take, let's say, a patent agent or a patent attorney's help, which typically will be outside of your, office. And there are patent agents and attorneys. And step 3 could also be done with their help. And yeah, if you are doing as an individual, and of course you could do many of these things individually yourself, or you could again take help from third-party companies to do it. And important point is, patent is a first to file system, right? This is something that we need to very clearly understand. So what does it mean, right? It's not first to invent, right? It is first to file system. Let's say company A invented something, right? A method or a product or an apparatus called XYZ in 2015, but filed a patent in 2018. Right? And then there is a company B, which actually, let's say, something similar, right? So they did in 2016, but they went ahead and filed the patent in 2017, correct? But now, even though company A actually invented this first, so now, because A did not file for a patent, the patent will not be awarded. The patent and the rights that come along with the patent is not going to be granted to company A, but it will be rather granted to company B. So I think the similar kind of concepts will also apply to teams, engineering teams within a company. So it is very important to keep a documentation of your ideas and what you are doing, so that you can claim priority, right? So that is very, very important, right? So this is very important to resolve the resolution, the contention within teams. Right. And yeah, of course, patent is a first to file system, which we need to keep in mind. So then let's understand what is the patent flow process in India. So this is quite lengthy, but I'll try to summarize. So bring your focus to the blocks above the red line, right? So there, the first step is you file a patent application, right? And with complete specification. What does it mean, right? You draft the complete specification and information about what your patent is, and there are various sections that has to be there in a patent. So you do all those things and then file a patent, right? And so what happens is, after say 18 months, right, your patent gets published, right, in a journal. So patent is not awarded. The patent will be published in a journal, which will be available in a website in the India Patent Office, which will be available to the public. So for about 18 months, your invention will be kept sacred, right? The office, the patent office, is not going to say divulge it to the external world. So it will be kept secret. And likewise, if you are involving, let's say, a third party to file a patent, it is important to have some NDAs and other contractual agreement between that company, so that the intellectual property is protected, right? Because they do deal with they might be dealing with other similar people ideas. So we have to be wary of that fact. So what if if somebody wants to, let's say, file a patent, but then they are really not fully let's say ready with the drafting of specification or their implementation. So in that case, you could do a provisional patent filing. So provisional patent filing allows you to file the complete specification within 12 months of filing the provisional specification, right? So that kind of headroom is given in case you are actually not ready with your full implementation details and specification. So you could do that. So that is just below that red line, and above this green line is what I'm talking about. In any case, this will be kept as a secret. So what happens after 18 months is, as I told you, this the patent is published in a journal in the IP India website. And so this is the time when actually you can, after this, this becomes public, and others can also see it, right? So so what you could do is between this time, right, you could actually request for examination. There is a step called request for examination, which is a very important step. And this is not something that automatically happens, and you have to explicitly request for it. And only after this step, actually the patent moves to the next step. So as part of this step, so a detailed examination is done, and the patent office will try to see if there are any infringement, and whether the patent has the novelty aspects and things like that, or if there are anybody opposing this. And so all those kind of things happen during this stage. And then what is FER, right? First examination report is issued. And so after the first examination report is issued, either you could directly be granted the patent, or there could be some clarity that the patent office is asking, and you need to actually complete all those things within say 12 months of the issue of FER. If that is done, the patent is granted. Otherwise, the application is abandoned. So if you want to, so for you to file the examination request, you have about 48 months from the date of filing the patent complete specification or priority. So if you want to expedite that, meaning you don't want to, let's say, wait for this 18 months and you want to do something much earlier than that, it is possible for the startups and certain other scenarios. It is possible. So what qualifies you to be a startup, etc., is again detailed fashion. It is all there in the IP India website, and you can see that. So typically your turnover should be less than 25 crores, and you should not be more than 5 years into operations, etc., right? So it is possible to expedite, but all said and done, typically from say the date of filing a patent to getting a patent awarded, it takes anywhere from, let's say, 4 to 6 years. Typically that's an average time that takes in India. So you might want to plan things accordingly. And about international patent, so international patent could be filed through what is called as a patent cooperation treaty system, or a PCT system, right? So so what happens there is, so if you file application under PCT, you could actually seek protection in as many as 152 countries, right? And you could do everything through a single window system, and you don't need to go and file in each and every country that you want to cover. Nobody will go for covering or seeking protection in 152 countries, but it is possible theoretically. But typically you do it in 4 or 5 countries. Even then, it is a pain to go and individually file in each and every country, right? But this system allows, it's a single window system, and this system allows you to file one application, which could be done in, let us say, in India Patent Office as a receiving patent office, or World Intellectual Property Office called WIPO, and you could actually seek protection in more than one country, right? That is possible. And another advantage of going through the PCT system is it gives you, let's say, 30 months or 30 or 31 months headroom for you to file the patent, right? So unlike, let's say, the previous system that we spoke about, where within 12 months you have to actually file the specification, here you could wait for before 30 months you could actually go and file that, so it gives you that leeway here. So that is about the international patent filing and PCT system, right? So yeah, either you could do it through India Patent Office. So India Patent Office in that case will be called as the receiving office. And so for you to file international patent, it is important that you actually are filing it. Your patent should have been say, even if you file through WIPO, right, it will again come back to India if you are filing for patent in India, and getting or applying for patent in India is important for you to apply for patent or protection in other countries. Okay, so I think that's pretty much what I wanted to cover, and a little bit of patent trivia, right, to get some perspective. So in India, right, 5.1 lakh patents have been filed between, say, 2005 and 2018. So say 12 years time frame. So 76% of the patents are filed by the foreign residents abroad, right, and only 24% is filed by the Indians, correct? And this table you could see, the patents filed by Indians versus foreigners and their share, and also the top countries from where people actually file the patents, right? To put things into perspective, so Times of India had reported that Qualcomm alone, right, had filed more than twice the number of patents than the collective number of applications from the 50 labs under DRDO and CSIR, IIT, NITs, etc. Right? So this is just to get a perspective, right? So I think as Indians, we are very humble, and we don't, so it doesn't mean to say that we are less innovative, right? So we are innovative, but we don't really claim and take credit for our innovation and the inventions that we do. So we just don't care. So that's what I take from this as a perspective. And some more patent trivia. So there are certain individuals, right? They are called as prolific inventors. So there are people with, let's say, this guy Yamazaki, who is on top of the table. He has 5,730 patents, and he's just an individual, right? And Gurtej Sandhu, he has 1,357 patents. He's from India, so but he's an Indian American Indian, right? And so he works in Micron. So he has more patents than Thomas Alva Edison, as they say. So Edison, you can see the bottom of the table with this arrow mark showing, right? So Edison was considered as a prolific inventor with 1,000 plus patents, but then today there are people with Kia Silverberg is again a popular inventor that you will come across this landscape. Then in terms of the applications filed by Indian states, Maharashtra tops it with 3,700 patents. So it is only application. So I don't think that this is about the patents awarded, right? And then Tamil Nadu comes next, Karnataka, Delhi, Telangana, etc. This is just to get a perspective, right? Yeah. So yeah. So some useful references. So there is something called Espacenet and Google Patents and free patents online. So you could use these sites for looking up and finding if so for patentability search and for looking up other patents. You could use these websites. It's available for free, and I've also provided some other useful links, right, which I referred to for coming up with this presentation, which I'm definitely sure you could also use as well, right? So that's pretty much what I wanted to cover today for this talk. It's a short talk. If there are any questions, you can unmute yourself, and we can discuss that.
Hi, Madhu. This is Sahil. Am I audible?
Yes, Sahil.
So, very, very insightful presentation, Madhu. I must thank you.
Thank you.
I have one question.
Welcome, Sahil. Yeah.
Thank you. So, I have one question. So, the moment anything get published in a journal,
Right.
are there guards around? What if somebody pick up the topic idea or innovation and quickly file it in other country and get benefited out of it? Are
Right.
there any guards around?
Right. So that's a very good question, right? See, the moment you file in India, right, with that filing date, you can claim priority and you can start applying for international patents through WIPO or India Patent Office. And as I told you, it is first to file, and you could cite the dates on which you filed in India and claim priority in the other nations as well. As I told you, for patent to be awarded, that idea should be novel, not just in India, so throughout the world, right? So that's how it works. So you could claim that date as a priority and file for patent in other countries through this WIPO system or India Patent Office. And yes, so for 18 months it remains secret, but after that it will be there in the public domain. And yeah, if somebody is smart enough, they could actually go and work around your patent. So that's why what typically people do is they do what is called as patent fencing. So they also try to cover as many things as possible and try to put it in their patent claims. And other times they also go for multiple patents around say this particular patent. So there are various methods that you could adopt, but yes, you have to disclose, you have to divulge the information, because that's when you get a patent and IP rights.
Thank you.
Welcome.
Madhu, Sharath here.
Hey, Sharath, yeah.
Yeah, I was question. So normally the claim happens when somebody search for the patent and find that there is something matching. So most of the semiconductor things, it is hidden inside a chip, and basically nobody can understand what is inside and how it is done. So how can we claim those kind of patents?
No, you mean to say suing other folks because you think that they might be infringing upon your patent? Is that what
Right.
you are asking, or you are asking how
Right.
to? Oh, okay. Yeah. So I think that is yeah, that's a good question. So typically, I think you can find out, right? Based on as I told you, it's just the implementation that could be patented. But if you think, let's say somebody is working on a solid state drive, and so if you think, okay, possibly somebody could be infringing upon your ideas or your implementation, I think you have to use your let's say your own research and then go and actually sue them. And of course, you do take help from the patent attorneys, and yeah, that's how you do it, because in the patents you list down everything, right? You can for those things you can claim actually.
Okay, and one more question. So
because see, first and foremost thing is no two patents are likely to have been awarded to the same implementation. So what I mean to say is one single implementation cannot have two people or two owners, correct? There will be only a single owner for that particular patent. So if there is another similar patent, then it has to be different, and it has to be an inventive step, and it has to be novel. It should not have been an earlier patent. So that's about it. Yeah, you were asking one more question. Yeah.
It is about actually some kind of products. Okay, so if I patent something in India, and okay, as a producer or some production house, so where I know that there is a patent in India, but it's not patent in the US. So can I produce a product and market in the US and not in India?
Right. So see, if you are doing it in see, if a patent is protected in India, it is protected in India. That's it. So in other places, somebody could do it. They can do it, and you can't do anything about it.
Okay, yeah, got it.
So that's why you need to cover it, right, in multiple geographies. That's called that is something called free. There is something called free to operate, right? So many times you let's say if you are going to do it only in India, correct? Still you have to do some search called as free to operate and find out whether you are okay to do it in India, right? Whether if let's say you are not going for a patent at all, right? But you want to, let's say, do a product in India, you have to still do what is called as free to operate, because somebody would be claiming that as a patent elsewhere.
Okay.
Right. So there may be other copyrights and other things that you might be infringing, but still it is better to do what is called as free to operate.
Free to operate. Okay.
Yeah.
Okay. Yeah. Thank you, Madhu.
Yeah. Welcome, sir. Right. So there are no further questions. Then probably we can wind up, or I can take maybe 1 or 2 more questions. We have some time till 8 maybe. So I'll share these documents with you folks, and you can actually, I think it will be handy. And now you can, I'm sure you have some idea about patents and copyrights and stuff. You could do a better job, I guess. And I want everybody to at least have 5 patents, 10 patents, right? It's possible, and that way you can stand out. So go for it and let your creative juices flow. And thank you very much for attending. I appreciate the time taken. Stay safe. Thanks. Bye.
Thank you, Madhu.
Yeah. Bye.